Good morning, everybody, and welcome to this Garden Court Crime Team webinar. Thanks for joining us. This is the fifth in our series of webinars looking at the position of children in our criminal justice system, with a particular emphasis on the challenges posed by COVID-19. Today's session will give us a practical guide and case law update about children crossing age thresholds into adulthood and the particular challenges caused by COVID that may potentially arise from your own cases. My name is Rajiv Menon, and I'm a member of the Garden Court Crime Team. I'm going to keep the introductions very short. Before I introduce Brenda, Campbell, and Emma Fenn, today's speakers, there are a few instructions that I need to give. You will also find these in the chat window. I'm sure you're all familiar with Zoom, but you can click on it either below or on the side, whichever way your screen is configured. Firstly, you've all been placed on mute. There are presently over 60 of you dialed in, and we're expecting still more. And so to manage oral questions and with so many people would be difficult. So if you have any questions arising from what Brenda and Emma say, if you could post them in the chat window, and I'll collate them during their talks and ask Brenda or Emma to deal with them at the end of their comments. Secondly, the presentation slides of the lectures will be circulated to all registered participants. Thirdly, the webinar is being recorded. In other words, the audio and the video of the presenters and anyone who speaks will be recorded. And it may be shared on our marketing channels, including website and social media, but no other audio, video, or personal data will be recorded or shared. Fourthly, we'll be unable to assist with Zoom or video connection problems relating to your device. Obviously, this is a Zoom video webinar, and it's outside our control, and it may be dependent, therefore, on your internet connection or the functionality of any device you have. So we're sorry, we can't really help with that. If you're really stuck, put something on the chat and we'll see what we can do, but it's probably going to be very difficult. And finally, Brenda and Emma are intending to speak for about an hour or so, which should leave plenty of time for any questions that you may have. Turning then to introductions, Brenda joined Garden Court in 2005. She works both domestically and internationally, particularly in the north of Ireland. Her practice covers the whole range of criminal defense, inquests and inquiries. She recently represented families in the Hillsborough inquests and in the ongoing Ballymurphy inquests, and she took silk in 2018. Emma Fenn joined Garden Court in 2012 after working at Hickman and Rose Solicitors as a paralegal and at the Criminal Cases Review Commission as a case review manager. She's a specialist criminal defense practitioner covering the whole range of crime, including youth crime, serious violence, and baby shaking. That's it for my introductions. I will now turn over to Brenda and Emma.
Thanks, Rajiv, and thanks to everyone who is joining in by video and by audio. It's great to see all of you that we can see on our screen. We're very conscious that we have a great wealth of knowledge amongst those who are joining in. And in fact, a number of the cases and the points to which we will be referring will be points that you will either have assisted in establishing or no doubt will make on a relatively regular basis in your own practice. But we hope that in reviewing the situation for children and young people, so children who are not yet 18 but who are approaching their 18th birthday, and for young people who are perhaps turning 18 and will be 18 by the time any criminal proceedings reach the court in relation to them. We hope that in really rehearsing and reviewing some of the basic principles in the case law, that it's of some assistance to you all. The proposal is that I will tell you a little bit about where we're going to go in the course of this Zoom seminar, and then I'll hand over to Emma, who will focus to a significant extent on those who are still not 18 or who might be 18 at the moment and risk turning, might be still a child at the moment and risk turning 18 in the not so distant future. And then I'll focus a little bit at the end about the approach to sentencing for young people who have just turned 18 or are still young adults at the time of their conviction, and we look at some of the case law in relation to that. So I'll give you a little bit of an overview on where we're going before I hand over to Emma and then take the baton from her again towards the end. And we're going to try our best to stick to the time frame that we have. These slides that you're going to see, and hopefully you all can see on your screen at the moment, will be available to download afterwards. So don't feel the need to make a note unless you really want to. The basic principles of what we're going to look at are the fact that the key date that we need to focus on for children and young people before the criminal courts is the date of conviction when deciding whether youth sentencing powers or adult sentencing powers apply at the time they come to be sentenced. Really, the date of the sentence is neither here nor there, subject to one exception in relation to the release of prisoners, which we will touch upon. So the date of conviction is key in deciding on the sentence, but culpability should be assessed as at the age of the commission of the offence. And I add to there that culpability should be assessed not just at the age of the commission of the offence, but as we're going to look at in an assessment of the individual's maturity at the time the offence was committed. So the date of sentence itself is not, as you will know, the relevant feature. But whether you're an adult or whether you're a child at the time of your conviction can, as Emma will go over in a moment, make a very significant difference in a number of respects. It might make a difference in relation to when a conviction becomes spent, and therefore in relation to future criminal record checks. It might make a significant difference in relation to any requirements vis-a-vis the sex offenders register, and it might well make a significant difference in relation to the release date. Many of you will be aware of the 2009 order in relation to the release of prisoners, altering the release date of their sentence. And that applies to those who are 18 years of age at the time of sentence and being sentenced for serious offences which carry a term of 7 years or more. The starting point where a crime is committed as a youth but convicted as an adult is the sentence that you would have received at the time, and hopefully we'll look at a number of helpful cases in relation to that. And all of this is premised on the basis that in recent years there is an increased understanding, we hope, and in fact we have seen in the criminal courts, the Court of Appeal and the Crown Courts, in relation to the process of maturation of young people, particularly those who are on the cusp of turning into adulthood, who are turning 18 or have just turned 18. There is an increased recognition as established in case law and also in the guidance and the guidelines that turning 18 itself is no longer a cliff edge when it comes to sentence and should not be treated as a significant turning point, and that the courts need to bear in mind and give heightened consideration to the process of maturation and really the process of growing up. A lot of this, as some of you will know, is born out of an increased understanding as to adolescent brain development and the fact that young people and young adults continue to mature. It's now recognised well beyond their 18th birthday and in some cases up to 25 and beyond. And for that reason, if you are representing a young person who has just turned 18 or indeed a young adult in their late teens or early 20s, it is very useful to look at the sentencing guidelines for children and young people as an approach. So for the purposes of your own practices, you might want to be considering all of those whom you represent at the moment. In relation to offenders who are on police bail or who are released under investigation at the moment, you might want to consider the age of any who are approaching 18. Consider the date in which they turn 18 and the impact of that 18th birthday and that it might have in relation to the proceedings that they potentially face. And whilst none of us are in the business of seeking to accelerate prosecutions, it is worthy to pause and to reflect on whether anything can be done to accelerate the process, because it can make a huge difference to outcomes, particularly as we put down in relation to sexual offences and the requirements to register if an adult by the time of conviction, and also in particular when dealing with young people who have still not attained their 18th birthday, consideration must be given to whether a child would be eligible for a compulsory referral order should their case be dealt with in the youth court before they turn 18, rather than the consequences of waiting until they're 18 and facing an adult conviction. And for those who have been charged and who are awaiting trials in the youth court or the Crown Court, again, think about whether any of those young people are about to attain their 18th birthday and what the consequences of that might be. If in fact it's the case that might well resolve by way of a guilty plea, consider whether that first appearance can be moved forward, even by video link, or an indication might be given by telephone on a first appearance, so that their conviction date is prior to the 18th birthday. And consider others who are approaching 18 with hearings adjourned off. Is it going to be possible to resolve any of those before they turn 18? Of course, all of this must be done as far as possible in conjunction with your clients, bearing in mind the difficulties that many of you no doubt will have in contacting clients who are detained in secure training centres and the like at the moment. But if there are cases where turning 18 is likely to make a huge difference, and indeed that's most of them, consider whether anything can be done to expedite the process. And I'll hand over to Emma to take it from there.
And we wanted to just really set out in the next couple of tables about something that we sometimes forget. It is as important to people's futures as we might be more focused on the criminal proceedings. So we just wanted to put side by side the difference between when you have somebody convicted as an adult and when you have somebody convicted as a youth. Obviously, at the moment, making progress is even more difficult than we usually find it, and we certainly don't make any suggestions thinking that anything would be easy. But when you look at this table, there are some huge differences between being convicted as a youth and an adult. And we all are well aware that in terms of DBS checks, if you're convicted as a child, they're viewed slightly differently, particularly with recent Supreme Court case dealing with when children in effect have got in trouble versus adults. So the difference really can be hugely significant. Taking several examples, in effect, it's around half. So we can see with the community orders and the YROs, it's 6 months versus 12. Fines, again, the same. And so you can see that there's a considerable difference, particularly when you get into the medium-term prison sentences, of when a conviction has become spent. And whilst clients aren't necessarily focusing on that at the time that they're in trouble, we know in the future that can have a huge impact on them. So this table, hopefully just a helpful thing that you can check back to if you want to have a quick look at what the differences are or highlight those. And the same can be said for the next slide, which is the sex offenders notification requirements. Perhaps to give one particular example, sexual assault, as we know, has particular requirements as to when you would trigger the sexual offence notification requirements, but particularly for youths. If you're convicted as a youth, you in effect need to have been sentenced to detention to find yourself on the register for sexual assault, whereas if you're an adult, a community order of 12 months or more will find you on the register. So huge differences, not just in terms of what the length of the notification requirement is, but sometimes the initial trigger as to whether you even have to register. And I'm sure we can all think of examples in our caseload. I once represented somebody who'd been on police bail for 2 years for possession of indecent images. He was 16 at the time of the commission of the offence and 18 by the time of the conviction. And in the end, a judge was persuaded to give him a community order of under 12 months. because that would have mirrored the impact that he would have faced as a youth in terms of the sex offenders notification requirements, but obviously much worse situation to have found himself as an adult with that conviction rather than as a youth facing a referral order. Couple of examples, again, pretty much half throughout medium-term prison, 5 versus 10 or 3.5 versus 7. Community orders 2.5 years versus 5, and you can see that table, and again, hopefully something that you can refer back to. At the bottom in brackets, the restriction order is indefinitely in both incidents, but otherwise it's 7 or 3.5 years for a hospital order without restrictions. And so Brenda and I, having set out what we described as kind of the basics or the framework for today's session, the rest of the session is going to be split into 2. As Brenda mentioned, the first part is me just covering where somebody was a youth, 17 or under at the time that they committed the offence, but perhaps 18 at the time of conviction. And what do you need to back it up when you find yourselves in the magistrates court, the Crown Court, in trying to persuade judges that they shouldn't go down the route of looking at the adult sentencing guidelines, but that you can pull them far away from those? And what can we give you to back these up? We're not going to spend loads and loads of time going through each of the cases, but we hope that this will act as a little bit of a guide that you can jog your memory from it if you want to. Hopefully these cases should mainly be known to you, but a few more recent ones that are applying previous principles. So the absolute basics, it's the date of the commission of the offence that is not the critical feature. So where you've got somebody who's turned 18 before his first appearance, but the offence was committed under 18, that's not what matters. As soon as they've turned 18 and they've got to their first appearance, the youth court no longer has jurisdiction. So the date of the commission of the offence is not the critical feature, and that's the Uxbridge Youth Court case. Instead, what's the important feature is the date of conviction, and I'm sure you'll be bored of that line by the time I've finished, but a case that sets it out really quite nicely, Abbasi. It's useful to just remind us all of these key features, which is that the date of the conviction determines whether you're an adult or child for the purposes of sentence, but the date of the commission of the offence determines how your culpability should be assessed. And little quote there from paragraph 6 that can just be used is just talking about that, where you cross a relevant age threshold, culpability, date of commission, but sentencing powers based on the date of conviction. So dealing with being under 18 at commission and over 18 at conviction, this case and the following cases that apply it are incredibly useful to put in sentencing notes or to raise orally at sentencing hearings. The starting point for somebody who finds themselves in this position should be what a defendant would have received at the time and age that they committed the offence. This could be even more important during COVID-19 because the gap between conviction and sentence, or commission and conviction, could be hugely significant. We could find that people are facing not only the years that we can now expect on IUI, but beyond that, the gaps between the times that they get their hearings, when they might be able to enter pleas, and when their sentencing hearing might happen, particularly if on bail, are going to be even more drawn out. So this is perhaps going to be a really important line of case law over the next 6 to 18 months, perhaps. GAR4, and I've set out the relevant factors and features from GAR4 there. Where an offender commits an offence before he's 18, but is 18 when he's convicted, the starting point remains the sentence he would have likely received had he been sentenced at the date of commission of the offence. And if you want to depart from that approach, you need good reason. So in effect, a presumption. The presumption is, what would somebody have received if they were 16 at the time? Again, we've got to look back at the compulsory referral orders. If somebody would have been eligible for a compulsory referral order, we know that that means that once they get to the Crown Court and they're over 18, there are no powers to give referral orders to people over 18. But what does that mean? We need to be drawing comparisons between referral order, how long it takes to become spent, whether you would attract sex offender notification requirements, those kinds of things. It's not just simply about what the sentence is, because the sentence isn't available anymore, but what are the comparisons? So are you looking at a community order? Would a community order be too onerous? Where is the proper level that you should be looking at? In Gaffer, they looked at the statutory maxima for youths, which we all know, of course, is 2 years DTO, but reinforced that it isn't the maximum that we're dealing with. You have to go back to the starting point. So don't allow judges to think of 24 months as a go-to starting point. As we know from our caseload, it's really quite rare that you get a youth who receives a 24-month DTO in serious cases or very borderline cases, whether they're going to be committed. In Gaffer, perhaps significantly, there was quite a small gap between commission of the offence and conviction. And I imagine that that's what enabled the court to go down this line, but it's become a really useful line of authority. And you'll see that it remains good authority in the slides that follow. Backing that up, it's also cited in the youth sentencing guidelines. There's a section on crossing age thresholds. You can see I've just reproduced it there, 6.1 and 6.2. This includes, in paragraph 6.2, this includes young people who attain the age of 18 between the commission of the offence and the finding of guilt. And that's GAR4. And what they're asking you, in effect, to refer to is, although the adult sentencing principles apply from section 142, you still have to look at that starting point. And of course, that might give you greater reasons to argue that reform and rehabilitation, prioritised as they are in the youth sentencing guidelines, should be prioritised in the situation where somebody's 18 at the time of conviction and sentence, but was younger at the time of the commission. Another case that deals with GAR4, Keffer, and there's been a number of areas and cases over the years that have talked about GAR4 and whether it should be applied, and some have stretched it and some have tried to pull away from it. But this line of cases really shows that it is something you can continue to rely on. And Keffer pretty much just goes straight back to GAR4 and says, clear authority, a judge does not need, except in rare circumstances, to think about a sentence other than one which would have been passed at the date of the offence. So again, really pushing the presumption angle and adding, in effect, a layer onto GAR4. And then this is not just, you can see from Keffer and GAR4 that we're not, these are not massively recent cases, 2002, 2015, but they're continuing to be applied. Agedja in 2017, a bigger gap than in GAR4, much bigger gap between commission, conviction, sentence. Here, a period of, in effect, 3 years. He was 17 at the time of the commission, 19 at conviction, and 20 at sentence. So it doesn't just apply to where you have very short periods of time. The Court of Appeal looked at it, and the judge had given a 30-month sentence, and they looked at it and they said, no, that wasn't appropriate. And a really quite significant reduction from 30 months to 20 months. And I think when I looked at this case, that meant that he had quite a small number of months to go before his release. And the Court of Appeal were critical in saying that insufficient regard had been had to his age at commission, and they critically applied GAR4. And more recently, again, 2019, Menon, 17 at the time of commission. You start to notice a theme. 18 at conviction and sentence. In that case, the judge imposed a sentence of 4 years. And although in this case, as we know from GAR4, they say don't rely on the maximum, these were serious offences that were being dealt with, and the Court of Appeal, again critical that the judge had failed to consider the GAR4 line of authority. And that sentence was again reduced hugely significantly from 4 years to 24 months, halved by the Court of Appeal. And again, those paragraphs there, if you want to go and look at that case, you can do. 14 to 20 deal with the fact that this still remains a secure and useful line of authority for us when we're dealing with these tricky cases. If you look at historic sexual offences, they have been treated slightly differently, but that's obviously not the focus of today's talk, so I haven't gone into it. But there are cases where someone hasn't been prosecuted for 20 or 30 years, and they may have been 16 or 17 at the time. The court has treated those differently, but perhaps most importantly, they haven't when it's come down to when somebody remains a young adult. So yes, when somebody's into their 30s, 40s, 50s, there's a slightly different approach. But when you're dealing with young adults, they still are grabbing onto the approach in Garfor. And that's perhaps nicely illustrated by this case here. The defendant had committed sexual offences when he was 15, but was not convicted until he was 19. And in this case, they said that in effect, the Garfor approach was the right one, rather than to adopt the use of the historic sex offences principles that have been applied in other cases. So it's really important that, in effect, a lot more sympathy if we're dealing with young adults. People, as Brenda said, brain still developing, a huge amount more research coming into the public eye about it, and something that the Howard League are pushing, which we'll cover a bit later. Now, we always focus on the 17 to 18 threshold, but just one brief slide about other age thresholds. We will all have relied on, I'm sure, at some point in our careers, keeping a 14-year-old out of prison because they're not a persistent offender. The offence is serious, but you can avoid them getting a sentence of detention because of their lack of being a persistent offender. Now, in this case, LM, the offence was committed at the time when the defendant was 14. He wasn't a persistent offender. He didn't satisfy the definition, but was 15 at the time of conviction. And in this case, Garfor was again utilised to say that because this wasn't within the defendant's control, that he was convicted at 15 rather than 14, it was inappropriate to impose detention where detention couldn't have been imposed had he been sentenced at the time of the commission of the offence, namely when he was 14. So again, the starting point remained the sentence that would have been available at the time of the offence. And those utilising LM in that way could make a huge difference between somebody on the 14, 15 age threshold. So whilst the focus in this seminar is on 18 and the move into adulthood, let's not forget that there are, of course, other age thresholds that are worth bearing in mind, and case law that can help us there as well. And now I'm going to pass back over to Brenda, who's going to cover where you're over 18 at the commission of the offence.
Thanks, Emma. What we're going to look at now are those young people who, you know, fresh out of lockdown and keen to seek revenge for whatever social media slight has been slurred upon them in the meantime, or have been arrested just after their 18th birthday, or indeed in the year or years afterwards. The point essentially that we make before the court is that, you know, an 18th birthday or even a 21st birthday does not in itself confer insight or wisdom or self-control once you pass that age threshold into adulthood. And in fact, in many cases, as we will know just from our experience in encountering young people, chronological age of 18 does not reflect the reality for an individual's age or maturity. And so what do you do when you're representing a young person, as in fact Stella and I did just a few months ago, who had 5 days after he turned 18 been arrested and was being prosecuted on an allegation of murder. And in fact, in that case, he was arrested and prosecuted with 2 other young people, much younger than he was. They were 15 at the time and he was 18. And the approach that we took in that case, and it's helpful, it's not a case that we're going to look at in particular, but it's helpful to know that the court approached all of the young people in that case as young defendants, treated them all as young defendants. And we were absolutely adamant that just because he had turned 18, and in fact was almost at 19 by the time the case finally finished, we were not going to have him treated in any way differently than the other young people before the court. it really did make a very significant difference, not just to the verdicts that the jury returned, but really to the whole atmosphere and the temperature within the court when we were dealing with a young man who we were saying, yes, he's 18 years of age, but developmentally he is immature. His immaturity is compounded by other aspects. He in fact had autism, but you might well find that immaturity is compounded by other learning disabilities or other vulnerabilities. And so the point that you make is that the court should approach young offenders who have turned 18 as still young offenders who, by reason of their circumstance, are potentially much less mature than their chronological age would suggest. The first case I want to look at is actually quite little known and hard to get hold of. There isn't actually a judgment, a full judgment in circulation. There is only a case digest, but if you can get access to it, we should perhaps in fact include it in the material that you can download at the end of this seminar. It's a case where both young appellants were 15 years old at the time of commission of what might be thought to be a fairly standard robbery. It was a robbery at knife point, and the judge approached the sentencing hearing by identifying the starting point and by then reducing it for their youth, and thereafter taking into account aggravating and mitigating factors. And the Court of Appeal said no, that the approach to sentence of young offenders, and this applies, I should say, to young offenders who are not yet 18 and can be used for those who have passed an age threshold. The approach to sentence, although it's not a mechanical or mechanistic process, should be that firstly, it's essential to work out what the sentence would actually have been imposed on an adult. And so what that means is you identify the appropriate starting point. You then determine what the aggravating and mitigating factors might be and what the notional sentence would be on an adult. You then reduce for a guilty plea, if there is one. And only after that should the youth discount be imposed. And that actually has the potential, because the youth discount might be half. If you're dealing with an offender who's under 15, might in fact be as much as 2/3 of the notional sentence of an adult. So if you approach it in that way, what is the final sentence that an adult would receive? And when you've got that final sentence, you then apply the youth reduction. That has the opportunity of firstly making sure that all of the sentencing aggravating and mitigating features are considered before discounting for age, and therefore you ensure, said the court, that the objectives of the sentencing guidelines in relation to children and young people are achieved. And what it meant in the case of D is that for one of the young people, instead of serving, I think it was 3 years and 8 months for the attempted robbery, he in fact served something closer to 3 years, which for children and young people, as we know, is a significant amount of time. So I'd urge all of you to get a copy of that case digest and bear in mind when a sentence hearing is approaching, either for a youth or a young adult in the criminal justice system. And after that, we're going to look at a conjoined appeal. And again, it's a case from some time ago. You may well know it. It's an appeal of unrelated convictions in murder cases for Peters, Palmer and Campbell. And in that case, the court was at pains to point out that, again, as we know, although an 18th or 21st birthday represents significant moments in the life of a young person, they're not necessarily indicative of maturity, insight and understanding. And so the first stage in the process is to select this prescribed statutory starting point, and then to allow where the offender's age affects it, his culpability and the seriousness of the crime justifies it, a substantial discount from that starting point. And what the court in Peters observed is essentially that, you know, although there may be a situation, as there was in the case that Stella and I just finished, where an offence was committed a short time after a 18th birthday had been passed, a rigid approach to the application of, in that case, Schedule 21 would mean that that very slight time difference, in Peters it was 3 months, in our case it was less than a week, But that very slight time difference could mean a very substantial difference in the years of sentence imposed if you approach it rigidly. And sentencing decisions, the court said, cannot be prescribed by such accidents of time. So therefore, when you're approaching the sentencing process in relation to offenders aged up to 21 or even beyond 21, the determination of the minimum term, in this case in a murder, was in accordance with the legislative framework, and it had to be approached with, the court said, an acute sense of how inevitably imprecise the statutory criteria may sometimes be to issues of culpability and ultimately to seriousness. So again, if there are points to be made in relation to young adult offenders between 18 and 21, and in fact, when you look at the sentencing guidelines and the research that has been carried out in recent years beyond 21 and up to a 25th birthday, if there are points to be made in relation to that young person's culpability as a result of their maturity, if not in chronological years, then those are points that we should very much be making. And the next case that we want to look at was an Attorney General's reference in the case of Clark, Andrews and Thompson. This reference, in fact, applied to 3 offenders who were aged 17, 18 and 19 at the time. I don't know if you can come on to the next slide, Emma.
Yeah.
17, 18 and 19 at the time, and it was a very unattractive set of circumstances. They had pleaded guilty to kidnapping, to blackmail, to offences of attempted robbery, perverting the course of justice. There's a bit of handling stolen goods in there. There was a few possessions of offensive weapons. And the Attorney General appealed on the basis that the sentencing approach in the Crown Court was unduly lenient. And that the Crown Court essentially gave too much leeway to their youth and not enough to the aggravating features of the case. And if the court wanted to roll back on the point that turning 18 is not a cliff edge, or wanted to roll back on the points and the gains that had been made in relation to maturity vis-a-vis chronological age, in many ways this was the case in which to do it. The young people before the court had a long list of previous convictions. One of them had as many as 42 previous convictions. The sentences that were imposed in the Crown Court were significant. 7 years imposed on 2 of them and 5.5 years on the other. But the Court of Appeal really resisted the arguments that were being made and was, if you like, essentially stuck to the point that turning 18 is not a cliff edge for the purpose of sentence, and that really youth and maturity can have and should continue to have a very significant impact when it comes to sentencing of young adults, in this case, essentially up to 25. And that youth and maturity continue to be those very strong mitigating features. And what we see in this case in 2018, and it's interesting, and I'll come on to it in a moment, but that the court has begun to recognise the experience of science, that young people can continue to mature, that maturity is not just if you like, a psychological process, but it's a physiological process, and that the brain continues to mature, albeit at different rates, for some time before their 18th birthday, and therefore youth and immaturity can be potent factors. A lot of this comes from a recognition in science and in neurodevelopment that the adolescent brain continues to develop. And in fact, that science was recognised in a number of cases in the US, particularly when it came to imposing the death penalty on on children and young people. And there was an attempt in Jogi, I don't know if many of you know, it was an intervention by Just for Kids Law to persuade the court that really the impact of the process of the young brain continuing to mature should be considered when considering joint enterprise and a young person's ability to foresee the consequences of his or her actions and to sign up to them in joint enterprise cases. The court really didn't want to engage with it in any direct way for the purposes of an appeal against conviction, but for the purposes of sentence. Not just the courts, but the Sentencing Guidelines Council, and in fact, a number of reports in the House of Commons Justice Select Committee have been much more open to accepting that young people continue to mature as a physiological process. And so if you do have any evidence to support the fact that although you're representing someone who is 18 or 21 or 23 or 25, that they are in fact an immature individual, it is very much worth gathering that before sentence and putting it before the court on the basis that having reached a significant age threshold doesn't mean that they have reached a significant maturity threshold. And so the cases continue. David Emanuel, who I think actually might be on this Zoom call, took an appeal on behalf of Mr. Balogan. It was a relatively recent case, 2018. Not a very attractive set of circumstances, it has to be said, but a young person who had committed a series of serious sexual offences within a short time of his 18th birthday. And again, the court in that case was loyal to the guidelines that have gone before and observed that sentencing guidelines for children and young people should be considered even when dealing with someone who is over 18. And it's that point that we see again and again, a young adult does not become invested overnight with all the understanding and maturity or in self-control of a fully mature adult. In fact, the court observed that the fact that within a few months of becoming the 18, the appellant had committed a series of sexual offences so grave as to merit, if he was a mature offender, a total sentence substantially longer than his life to date, made it all the more necessary to consider all the factors relevant to his offending. And David achieved a very significant discount in his sentence before the Court of Appeal. And then finally, again, on this topic, the approach of the Court of Appeal in Daniels, the 2019 case. Daniels was the type of case that many of us will have encountered in our careers. He was 20 years of age, who ultimately entered a late guilty plea to an offence of causing death and serious injury by dangerous driving. It was a joyriding incident. There were other young people in the car, and all of the aggravating features. He fled the scene. He had to be apprehended by local residents. His first appearance, he came up with a defence of duress, which he maintained, ultimately pleading guilty at a relatively late stage in the proceedings. And he was 20 years of age at the time of the offence, so not a very attractive set of circumstances. But the reports that his team were able to put before the court showed that he had a mental, essentially a very low level of intellectual functioning. They showed that a psychiatrist took the view that he was particularly immature and that he was highly vulnerable. And so really that report was undoubtedly very important in terms of not just explaining the immaturity, if you like, in his presentation before the court, in raising a defence of duress, in his actions on the night itself, but also in persuading the court that his chronological age was not the age that ought to be considered as paramount when dealing with him in sentence. And there's a lovely quote, essentially, that, again, as we've looked at, that this young adult does not become invested overnight with all the understanding and self-control of a fully mature adult. And so do consider in these cases whether you can gather that type of information, whether there is a report that we can put before the court that supports your view that your individual's low intelligence or immaturity or his lack of culpability can be supported by expert evidence, because again, it can make a significant approach to the difference in the sentence. And it also reinforces the need to look at the sentencing guidelines for children and young people, which, if you look at it, are particularly helpful. If we can go on to the next slide, please, Emma. The next one again, please, the Howard League one. As Emma has already mentioned, both the Howard League and Just for Kids Law have been doing a fair amount of work on this, arguing for the introduction of a sentencing guideline for young adults. That is, in fact, supported, as I've already said, by the reports of the House of Commons Justice Committee in relation to the treatment of young adults in the criminal justice system. And it's worth having a look at them. There was a 2014 and 2015 report, and again, a more recent one, I think it was last year, supporting the research that the sentencing process as it stands in relation to young adults does not sufficiently factor in the lessons that we now know from neuroscience, psychology, criminology, and the like. But in fact, you will find some support for those arguments in the sentencing guidelines for children and young people. And so if you are finding yourself in a position where you're representing a young adult on a sentencing hearing, do download them, do take them with you to court, and don't be afraid to refer the sentencing judge to them. The next slide sets out a paragraph of particular assistance, but it's by no means the only one. Thanks, Emma. Paragraph 1.5 of the most recent sentencing guideline for children and young people reinforces that it is important to bear in mind any factors that may diminish culpability of a child or a young person. And it reinforces that point about maturity that we've already indicated. Because maturity can impact on their decision making, on their risk-taking behaviour. It's important to consider the extent to which a child or young person has been active impulsively, and whether their conduct has been affected by inexperience, emotional volatility, or other negative influences. And if you have a case where you can put before the court that the young person has not fully appreciated the effect of their actions, it can have a significant impact on the outcome. In one case that I was recently involved in, two defendants had pleaded guilty to manslaughter. A third defendant had maintained a not guilty plea and saw the case through a murder trial that ended up in hung jury. At the outcome of that murder trial, and when facing a retrial on murder, he eventually pleaded guilty to manslaughter. In that case, he was older than the first defendant who had pleaded guilty to manslaughter at the outcome, and so didn't necessarily have the benefit of putting forward an argument in relation to his chronological age. But we were able to put forward an argument that his maturity, his levels of consequential thinking, the impact of his remand in custody had such a great impact on him that he ended up with a sentence that was less than the individual who had pleaded guilty to manslaughter at the outcome at the outset, notwithstanding that he had had a trial on murder and pleaded guilty just a few weeks before his retrial on murder was due to commence. So consider what information you can put before the court in relation to young adults in that way. And remember that the impact of punishment, paragraph 1.8 of the same guideline, is likely to be felt more heavily in relation to a child or young person in comparison to an adult. And also remember, and this comes back to the case of D that we looked at the start, that the guideline states that when you are considering an adult guideline, the court may feel it appropriate to apply a sentence broadly within the range of half to 2/3 of the appropriate adult sentencing guideline for those aged 15 to 17, and to allow a greater reduction still for those who are aged 15 and under. And the point is this, that if you're representing an individual who is 18, 19 or 20, but you can bring within these sentencing guidelines councils, guidelines in relation to children and young people, arguments that they ought to be approached as an individual who is substantially more immature than their chronological age will suggest, well, you have an opportunity to persuade the court that their sentencing discount should be potentially as much as half. On a good day, according to the guidelines, up to 2/3. But even in fact, if you only get a third discount off a sentence by virtue of putting immaturity arguments before the court, that will make a very, very significant difference to the outcome. So we will finish off this section just by reminding you, and undoubtedly this has been in your inbox from a number of different sources over the last few weeks, about the very recent case of Mammon, in which the Court of Appeal endorsed that the current conditions due to COVID-19 represent a factor which can properly be taken into account in deciding whether to suspend a sentence. And so if you are in a situation where you have maturity arguments to put before the court, where an individual has passed an age threshold, or in fact is a young adult, but in relation to whom particular points can be made, using the case of Manning, there may be, in some cases, an opportunity to persuade the court that those cases where custody might otherwise have been the outcome, there's a good reason in these circumstances to prevent that happening and to choose a non-custodial option or a suspended sentence. Hopefully those cases are of some assistance. It is important to remember, I'm sure many of you will have been in the situation that many of us were in prior to the 1st of April, were trying to get defendants sentenced, especially those who were coming within reach of the statutory instrument that came into force on the 1st of April. That would mean that those who were sentenced to a period of over 7 years were going to serve 2/3 of their sentence rather than half. It may be for many defendants that really the time has passed for that, because it applies to those who are sentenced after the 1st of April 2020. But do bear it in mind, because it makes crossing age thresholds all the more important and potentially all the more punitive going forward. And those are really the only points that and cases that I wanted to bring to your attention. Rajiv, let me pass back to Rajiv.
Thank you both for that. That was most helpful and illuminating. I'm sure we would agree. I'm just looking at the chat feed to see if there are any questions, and there's a couple here which I'll throw out there, and if you could address them, that would be great. The first is this: what sort of evidence would you look to obtain to show low intellect or maturity?
Well, if I can address that, Rajiv, what we did in the recent manslaughter case that we were in is we instructed a psychiatrist to comment on what we perceived to be potential post-traumatic stress disorder as a result of this individual's incarceration into, remand in custody for the duration of his first trial and then waiting for the retrial. And we got a really helpful report that indicated that although he was, I think he was 23, this really represented his first period in adult custody. And it had been very, very traumatic for him. And that the process in itself, he was remanded in Belmarsh, and unfortunately for him, because he had briefly left the country in the aftermath of the incident that led to his arrest and his remand, he was also remanded on a Category A wing. So it was particularly punitive for him. And the report was very helpful. The psychiatrist essentially said, look, he went into prison essentially a very young adult who was quite immature. He has spent now well over a year in custody, and it has had not only a very punishing effect on him, but it has made him grow up a lot quicker than he would do. And so he was sentenced on the basis that he was particularly immature at the time, and that the delay between the commission of the offence and the sentence itself had a salutary effect on him. But he should be sentenced as the young person who he presented at the time of the commission of the offence. And so I think a psychiatrist report, if there is one, it may be more appropriate, depending on the case, to have a psychological report as to levels of intellectual functioning, as to understanding, as to, essentially psychologists will be willing in most cases to comment on level of intellectual functioning and its association with maturity. But it may also be that it's something that a pre-sentence report focuses on as well.
Emma, anything to add?
Yeah, I think I've had educational psychologists, but really along the same line as what Brenda's saying.
I mean, I would just add that in addition to any reports from psychologists and psychiatrists, depending on the age, obviously, you may want to look at school records if there's anything potentially there of any use, or any other material from non-experts that could potentially be useful in persuading a sentencing judge to take a more lenient approach. I mean, obviously, that will depend on who the judge is and to what extent he or she is prepared to listen. But that's another potential piece of material you can put before the court. The next question is this: do these cases that you've mentioned have a gendered aspect? In other words, are young women expected to be more mature or vice versa?
I don't think there's been a huge amount of pushing the female angle, although I do think that the research demonstrates that the female brain is more likely to complete its development earlier. But I think the main focus of the Howard League and Just for Kids has been on male adolescents for obvious reasons. But I don't know if you've got anything in more detail to add.
I think it was in the case of Peters, the only case that we included that referred to a young woman was the case of Peters. It was a young woman who called Campbell, if I remember correctly, and the court didn't differentiate on the basis of gender, but she was one of the younger offenders, and it was in relation to her that the court made a lot of the more positive comments and soundings about the passing of the age threshold and the process of maturity. So I don't think the court necessarily, although science might draw that distinction, the courts, as far as I know, haven't.
David Emanuel, another barrister at Garden Court, has added something to the chat. David, do you want to unmute yourself and just make that point orally?
I've unmuted you, David.
Oh, hello, everybody. Yeah, I was just getting, thanks very much, by the way. Really interesting stuff. I just wanted to add something of relevance, which is the sentencing guidelines since October have been expanded. So when you now look at the mitigating features and you look at age and lack of maturity, since October they've been expanded quite enormously. So this is relevant to all offences that have a sentencing guideline for adults. And what's important about them is that they now basically include all the brilliant things that were said by the Court of Appeal in Clark and the cases that followed it. So for instance, they make reference specifically to young adults being typically aged between 18 to 25, still developing neurologically, and consequently maybe less able to evaluate the consequences of their actions, limit impulsivity. And it goes on at length, and it's just an addition to what's been said already, because it's obviously part of the guidelines, and it's a statutory duty for the judges to refer to the guidelines, and all practitioners probably need to have that in mind when they've got an 18 to 25-year-old, and that's the important thing. That's now enshrined in the guidelines. Even if you're representing a 25-year-old, you can still put forward, potentially, the lack of maturity. So I hope that's helpful just to bring to everyone's attention as well.
Thank you. Just 1 second. For some reason, I've lost my screen. There was one more question that I
can see one, Rajiv, about good precedents for low-level offences.
Yeah, that's the one. Could you just ask it, Emma? Because for some reason, my screen has vanished.
Yeah, no worries. Someone asking if there are any good precedents for arguing that it's not in the public interest to prosecute a defendant in the youth and adult magistrates courts concurrently, presumably where they've been convicted under 18 for one, and then other low levels when they're an adult. I tend to refer back to the CPS minor offences guidance, not that I'm sure that they necessarily follow it, because it's quite helpful, but that combined with the youth CPS guidance can sometimes be quite useful to include, because when you look at it, it often says that even where you don't have an admission of guilt, you should consider non-conviction disposals if you're dealing with low-level offences. I don't know if Brenda or Rajiv or David have any other areas that they tend to go to.
I've nothing to add to that.
No, nothing to add beyond it never does any harm to send a letter of representations. But no, nothing in particular.
I just noted, and you'll see it on the chat, that Millie Harris has added to the issue of gender there. I won't read it out because you can all see it, but there's an interesting point made there which may be relevant to the original question asked. I don't think there are any other questions. Can I just ask this of both of you? I mean, you've obviously highlighted the case law that has affirmed Gafoor, and where the Court of Appeal has been prepared to listen to arguments raised on behalf of appellants as to the importance of age and maturity in the sentencing process. But overall, do you think that the Court of Appeal has yet fully grappled with the extent of the medical and neurological research that there now is in relation to brain development up to the age of 25 and beyond? Or are we still, to put it bluntly, miles behind the science as far as the courts are concerned?
My experience is that the court is much more willing to grapple with it for the purpose of sentence than it is for the purpose of any appeal against conviction. But the court is still miles behind the science. I happen to know, because of another case that I was involved in, that Brian Levison was particularly interested in adolescent brain development as a topic. One of the leading experts in this field in the UK is Professor Sarah Jane Blakemore, and she was invited to essentially provide evidence to the Court of Appeal on the science of adolescent brain development. As I understand it, she did so. So the Court of Appeal is interested in it, but firstly, it probably depends very much on your court. Secondly, it will undoubtedly depend on the attractiveness or otherwise of the set of circumstances and facts before it, unless you're David, and in the most unattractive set of circumstances, you can nonetheless achieve a successful outcome. And there is a really significant move over the last number of years to recognise the science. The House of Commons Justice Select Committee heard evidence from the British Psychological Society on adolescent brain development for the purposes of their report, and that in turn is feeding into some of the changes that we see, the sentencing guidelines that David has just reminded us of, and the recognition that there is a process of maturity that continues beyond 18, beyond 21, and even up to 25. So significant progress has been made, and it's up to all of us to use it as much as we can in relation to individuals, and not just say you've got a 24-year-old and therefore it's a bog standard adult sentence with no other mitigating features in relation to maturity. But I still think there's a long way to go, and it is a road that really ought to take us out of just the sentencing framework and into how it is that young people are prosecuted, particularly in relation to joint enterprise offences, where they have to think through the process of signing up to an enterprise rather than just, as many of them do, go with the flow.
Yeah, and all of the research about which areas of the brain are the last to develop are really key on this, because they talk about decision making and consequential thinking and impulsivity. And it does seem to me that we're being pretty reactive. This is not, as I understand it, new science about when male adolescent brains finish developing. It does seem we're a bit late to the party, and there's a danger that the Court of Appeal will just give lip service to it. We're all very used to young men being convicted of murder and getting minimum terms that are similar to their chronological age, which when we're dealing with people who may be quite far away from completed brain development, it seems to me like we've got a way to go.
Yes, I mean, in terms of conviction, I'm thinking particularly of Thomas's judgment in Grant Murray, which just makes depressing reading, quite frankly, in terms of the fact that the courts are still way behind the science. I just thought I should mention as well that mention's been made of both the Howard League and Just for Kids Law. I mean, we're lucky in this country that there are so many organizations who are actually working in the youth justice field, in addition to those two. I mean, I'm thinking in particular of the Youth Justice Legal Center, Inquest, and others who highlight issues in relation to children and young people. And so I think a lot of use can be made of the material that all these organizations are producing in trying to persuade judges in criminal cases of the centrality of both age and maturity, not just in terms of sentencing, but also in terms of culpability in conviction cases as well. So I just thought I would add that as well.
Can I add to that, Rajiv, that I think the point at which we start engaging with the level of maturity of a young person has got to be from the first appearance.
Yeah.
It can't be left until the point of sentence. It is particularly important if you're going to have a jury trial to ensure that if you have a young adult, that they are treated as a young adult, that the court makes necessary adaptations if there are issues about maturity, levels of understanding, levels of consequential thinking.
Yeah.
And it is very important to really set the temperature of the court if you possibly can. And with some judges, it's easier, as we know, than others, but to set that temperature before the jury at an early stage, rather than to leave it until the end and then to say to the judge, oh, well, you know, he or she wasn't very mature, as has been apparent throughout the entire trial. And so if there are issues, don't leave them to sentence. Identify them early and make sure that to the extent that you can, you put them front and center of any prosecution. Thank
you, Brenda. There are no more questions on the chat. Astonishingly, we finished 20 minutes early. Usually we finish late. So I just want to give everybody a final opportunity if they wish to ask any questions. Given we have plenty of time, you can, if you have something you want to ask, rather than include it on the chat, you can just unmute yourself and ask it, because everyone is being very orderly. So there's no reason to do it by the chat. If anybody wants to unmute themselves, either ask a question or make a comment.
Rajiv, it's James Scobie here, and
yes,
I have been listening with sort of bated breath to all the authorities and things, but my experience with ever increasingly young offenders at the Old Bailey, and I appreciate it rather depends which judge you get, but I always seem to get Leonard when it comes to very, very young defendants, is that really, they try to give as much as possible to very, very, very young defendants and see what the Court of Appeal make of it. And I want to give you an example. I had a 14/50, he was literally 15, 1-5, on the date of this shooting, where he went along as effectively number 3 of the 3, and he was convicted, unfortunately, because he left his mobile right beside the victim, but also because, well, he was there, and this was seen by his face on the footage. And bluntly speaking, when he was convicted, his sentence went up from the minimum of 12 to 18. And we sent it to the single judge. And part of the RN from the prosecution and the judge's sort of reasons for giving him 18 years minimum was because when he gave evidence, he was actually quite mature for his age. In brackets, he was on remand for ultimately over 2 years since the actual incident occurred. We went through, and I kid you not, every last detail of, you know, look at the time of his age, his mum was in prison at the time. I mean, he ticked every single box. And I mean, the single judge said not a day too long. We had virtually all the authorities you've raised, we raised, and we're going up to the full court. And I fully expect, pro bono, I might add, I fully expect that the Court of Appeal are just going to just say good night. And I just think that, you know, I'm really pleased for some of these lads who get the results that you're getting. Maybe it's me, but wherever I come across a judge in the front line dealing with these top-heavy cases, they are looking to hammer them, and they are not looking in any shape or form to. I mean, they actually sidetrack the likes of Clark and Peters. I mean, we raise them all, and then the single judge says, well, on the facts, the judge was able to gauge the defendant. And, you know, I'm just sorry to say this, I'm a bit of a rant, but it seems to me that when you ask the question, are the authorities doing anything, you know, are they actually doing the sort of Leveson part? I do think they are. I don't think judges are in any shape or form seeking to give as much weight to age and immaturity as they should. And I think that these cases are not properly used by a lot of our regular frontline judges. And the more we take these cases up to the full court, the more we press the likes of Leonard and others to actually try and wake up, the better. But I fear we're fighting a bit of a losing battle. Sorry about that, but that's just an observation, not a question.
Thank you, James.
Classic lockdown negativity there, Scopes.
For what it's worth, I largely agree with James. My experience is very similar, but that doesn't mean that we don't keep trying and that
I think that's important. And I think James is right in that there is a obviously different temperature when it comes to murder versus, you know, other less serious. In fact, it was Leonard who gave us a lovely sentence on the manslaughter, even though we'd had a murder trial and then pleaded guilty to manslaughter at the door of the court. But not the most unattractive of defendants, it has to be said, and we did have a fair amount of mitigation to put before the court. But I do think that the key in this is going to have to be to keep appealing. And unfortunately, the truth is that we so often see in cases of the Bailey that children are given sentences that are substantially longer than the years that they have spent on this earth. And people go, oh, well, they had it coming. Oh, well, it's not worth having a try. Or, oh, well, we just create bad law or bad precedent if we take it on, so we won't. And in fact, in another case, Stella and I are appealing a sentence. And in real terms, we got the best outcome in the case, but we're appealing the sentence. Were our co-defendants who were convicted respectively of murder and manslaughter in Section 18 and who were 15 at the time, and the 15-year-old who was convicted of murder is going to be serving the same amount of time as the 15-year-old who was convicted of manslaughter will serve the same amount of time as the 18-year-old who had a significantly longer history of previous convictions. Well, we're appealing on the basis that it's still too long. But what is startling about that case is that we're up there alone and that those who represented principals aren't appealing.
David, you wanted to add something?
Yeah, I mean, I think...
David, do you want to unmute yourself?
Oh, we have to unmute him.
Oh, I was getting a message saying, can you hear me?
Yes.
Okay, sorry about that. Just in relation to James's comments, I mean, obviously I understand what he's saying, and it's more difficult, it's always more difficult when you have more difficult and more serious facts. It shouldn't make a difference, but we all know it does. There is actually a very useful case called Quartey, Quartey, that Judy Khan did, which was a Bailey gang murder, and the Lord Chief in that case concluded that there was immaturity just from the way in which this young man's life had effectively gone into a life of crime. The Lord Chief Justice seems to be behind a lot of these cases, and as we all know, it depends who you get in the Court of Appeal, whether you get anywhere, and the Lord Chief Justice is the person you actually want, very unlike his predecessor. So there are some successful cases of the most grave kinds, but obviously I understand what James is saying, and I saw the nods from others who are in the Bailey a lot. I think the reality is, for the less serious offences, less serious in inverted commas, in the regular comings and goings in the Crown Court, this is making a difference. It's part of the guidelines now. Practitioners are now aware of it in a way that they would never have been 5 years ago. And could you imagine 5-10 years ago saying to a Crown Court judge on a robbery that your 24-year-old should be considered to be a youth in some respects? You get laughed out of court. So there is a change, but these things are always going to be slow. But there is a massive progression, as has been mentioned, the Justice Select Committee behind this, all the other organisations. And this is actually something that is changing. I know from 1 or 2 judges that I've spoken to, they're keen to push this amongst other judges. And so I think it would be a shame to end on a note of pessimism. One tries to be optimistic. There is a wind of change, and it's undoubtedly, in my opinion, being brought by the Lord Chief Justice, and that is something. One other thing, and this is a plug really, for the Youth Justice Legal Centre, because I know they've got I've worked with Laura Cooper recently on a case, and I know they've got, I think I'm right in describing it as a handbook coming up, Turning 18 handbook. It's going to deal with all these issues. And I don't know if anyone from the organisation wants to say anything to add to it, but it's going to cover all these areas and give practical assistance to the practitioner. Have I got that right?
Whilst we're waiting for that, I think, Candice, you have a question. Do you want to unmute yourself and ask it?
Yes, hello, can you hear me?
Yeah.
Just about. You may need to speak up a bit.
Okay, is that better?
I can just hear you, yes.
Okay, I'll try and speak loudly. Just in relation to mitigation and chronology, just the impact of being subject to severe emotional, physical, and sexual abuse at home. So as a result of that, you might engage in behavior which is quite criminal only because home is not a safe place. So many of the people I work with, because I work with people who are homeless, have criminal backgrounds, but that's only because they've been subject to the most horrific of backgrounds at home. So in mitigation, is that something that can be raised? Because had they had a safer sort of upbringing, they would not have had that criminal background.
Brenda, Emma, do you want to deal with that?
Yeah, the answer is undoubtedly yes. Candice, at every level, it should be raised, regardless of how relatively menial or serious the offences for which they fall to be sentenced. In fact, it should, in my view, be considered at the outset if you're representing somebody who has been the victim of serious sexual or physical criminality. You might want to consider what you can do with that information in order to see whether there can be a diversion in any way from prosecution. Consider whether the national referral mechanism can help you in any way, or in fact it's a matter of representations to the CPS. But undoubtedly, yes. I mean, you know, from the most lenient of sentences right up to the toughest, the background of the individual has got to be considered, and the effect of any criminality that they themselves has experienced. And it touches on the case of Quarty that David just mentioned, where the Court of Appeal recognised that the background to the offender impacted on his level of maturity and the life of crime, essentially, that he was led into.
Thank you, Brenda. Does anybody from who's joined in today from the Youth Justice Legal Centre want to add anything to what David said earlier on?
Yes, I would. We are publishing what we're calling a practitioner's guide to on the topic of turning 18, and I suppose while it's quite comprehensive and it looks at both those who are approaching the age threshold, those who are crossing it and those who have crossed it, I suppose I hope it will add to your knowledge from today is how important the early stages of a case are. The delay caused by release under investigation is really significant, and actually if we can speed up the process there so that children are able to benefit from the out-of-court disposals available to them, then that can really sort of fix the problem before we all have to get so far as into the sentencing process. So we're publishing that next month and we'll circulate it. I hope it will be useful.
Thank you very much.
Can I add something as well, Rajiv?
Yes, Jude, please.
Which is that I think race also plays a huge part in the way that the court approaches this. And we all know that in terms of the way the judges look particularly at young black men and the whole concept of people, them being supposedly more mature because of how they look, how they behave and all the rest of it, I think at times will definitely play into some judges' approaches in rejecting the idea that somehow this is a young person. And I think there's certainly evidence of that. And some of us are familiar with the concept of the over-strong or over-aggressive black men in terms of criminology and criminal activity and supposed criminal behavior. And I think this can be often applied to younger black men who might be either larger in stature or supposedly in judges' minds display characteristics which are older than their age. And while of course they would never explain that in any overt way, is going to go towards perhaps rejection of the idea of accepting that there should be an approach that sees them as younger, that their actual age. So I think that's one thing I would say, and I'm sure and I'm certain that impacts on the approach. Also, I'm part of a justice working party that is looking into disproportionality within the youth justice system. It's supposed to be for a year, but at the moment I think it'll be longer because of COVID. But one of the very significant things we are looking at is the age issue and this nonsensical cut-off point of 18. And I think that a lot of this material will be very helpful to feed into that. It might be that I ask one or other of you to come and do a talk to the main group, because we're looking, I mean, a lot of people know it, but it's not just lawyers who are on this panel. There's a whole range of different people, and I think some of the other people will be quite interested to actually hear what's being said in a real way. The issue's obviously been flagged up, but people don't necessarily know how it plays out in the courts themselves. So justice have got a bit of weight. So the idea, as we know, so the idea is that this is obviously going to go to senior levels of government at some point, looking at a whole range of issues around disproportionality in the youth justice system, around race, but this would feed into it. So you never know, there might be some changes for eventually.
Yeah, and I think everything you've said, Jude, is obviously I don't do just cases at the Bailey like Scobes. So the important thing to say is sometimes a 2-3 page sentencing note with some of these reports uploaded into the sentence section really do tie judges in when we're not dealing with the very, very top end of serious cases, but we're sometimes dealing with the difference between a prison sentence and a non-custodial disposal. And that feeds right into the physical appearance of the defendant's element, that if you've got some hugely built 20-year-old, if you've done the sentencing note and you're making the appeal, the Court of Appeal don't have that in their assessment at single judge stage. So if you've put those documents before the judge, you're almost kind of tying their hands to make it clear that they have to focus on it. So even in very simple cases, sometimes a couple of pages just setting out these most important cases and the most important features of them, I found to be effective. So I'll end personally on that slightly more positive note.
Brenda, you've got 2 minutes before we end. Do you want to add anything? Because there are no more questions or comments that I have on the chat feed.
I think Jude has just identified the topic for our next Zoom seminar. It's a topic in itself, isn't it? And it's a topic that feeds through every aspect of prosecutions, and again, not just sentence. One of my real bugbears, and it's a point that we've taken in a number of cases. And you'll see you've got a young black client who has a history of simple possession of knives, and they're accused of joint enterprise. In the case that Stella and I just did, our client barely knew. In fact, there was no evidence that he had ever phoned either of his two young black co-defendants in a stabbing case, and yet they applied to admit his previous convictions for simple possession, entirely independent of any group scenario, entirely independent of his co-defendants, on the basis that, well, if he was carrying a knife, he must have known that the other young black boys would also be carrying knives, because everybody knows in these groups, even if they don't know each other, that young black boys go around Hackney carrying knives. And there really did feel to be a particular racial stereotype, which we called out. Unsuccessfully, it happens, but we'll see what the Court of Appeal happened to think about it in that case. So I think, you know, we all know about the overlapping aspects of discrimination that we face on a regular basis on behalf of our clients, and that's a very important one to bear in mind.
Thank you, Brenda. Unless there is anything else, I'm going to bring this to a close. Thank you, Brenda and Emma, for your presentations, and thank you all for joining in today. Stay safe and see you at the other end, sooner rather than later, I hope.